Jacinda, I do.
Thank you, Mr. Chair. I want to return to the element of debate that my colleague, the Honourable David Parker, raised during the debate on Part 2 of this bill. And on this side of the House, this element of Part 2 demonstrates to us why we should be undertaking a dual process with this piece of legislation, because this appears from our perspective to be a drafting flaw in Part 2 of the bill. Now, as has been discussed previously, this bill derives a lot of its meaning through the cross-referencing of other acts, primarily the Parole Act, but also under Clause 10 of the Returning Offenders Management Information Bill, the Policing Act 2008. And that part of the bill makes particular reference in Clause 10 to the ability of police to detain returning offenders being the entire cohort, not just returning prisoners, for the purpose of taking identifying particulars. Now, it will seem obvious on first blush why we would want a provision like this in the bill. The ability for the police to detain is set out in Clause 10 for a period no longer than is reasonably necessary in the circumstances for a constable to take identifying particulars of the offender. Similar language to what's used in the Policing Act. In a sense, what we're doing here is allowing the police, once a returning offender comes back into our borders, to take relevant information for police files. And when I say relevant information, we've codified that in this legislation by cross-referencing the Police Act. And it's not just identifying particulars that we are seeking. For the purposes of the Bodily Samples Act, we are also seeking DNA samples where that prisoner qualifies under the Bodily Samples Act. But the bit that I want to dwell on again, because it was raised by David Parker, the Honourable Amy Adams undertook to take the issue away. But when the House rose last night, it seemed particularly clear to us that there will be no movement on this issue. And this is the problem. Under the Policing Act 2008, Part 3, Powers, Operations and Offences, Clause 32, it states that identifying particulars means in relation to a person any or all of the following. A, the person's biographical details. For example, the person's name, address and date of birth. We've already highlighted this will obviously be incomplete information given many of the people returning to New Zealand will not have a specific address. B, the person's photograph or visual image. C, impressions of the person's fingerprints, palm prints or footprints. Obviously here we're not talking about DNA because that's covered by the Bodily Samples Act. Nowhere in these requirements under identifying particulars in the Policing Act, which is the direct reference for this bill, is there anything about taking information about the nature of the deportee's offence or offences? Now, there's an obvious reason for that, according to the Policing Act, and that's because within domestic legislation, of course, if they are in a police station having their particulars taken, it's because the police have charged them with an offence. They, of course, know by default what offence has been committed. It makes sense. For this Act, we've got a completely different set of circumstances. For the Act that we're debating here, the person will have been charged and convicted in another country. We do not necessarily have that complete information. So when we take those identifying particulars, it would make sense that in Part 2 of this bill that we be very specific about allowing the police to require that information to be shared. Now, Mr. Speaker, one might argue, the Minister could argue, the officials might try and argue, that we might have that information from an overseas jurisdiction from which the person has been deported. We know that that may not necessarily be the case. And how do we know that? Well, Mr. Chair, because in our discussions with the Minister in the lead up to this bill being developed, Clause 27A, from memory, was added quite late in the piece because the Minister discovered that the 20 individuals who were being deported to New Zealand this week did not have complete information. Clause 27A in Part 2 has been added quite late by the Ministry of Justice, for good reason, to allow those with serious offences, Mr Chair,
Jacinda Ardern.
to allow those with serious offences, for instance, sexual assault, murder, rape, what we would consider to be serious offences, to have the courts required to issue interim orders unless there's any reason not to. Because we know that we may not have complete information about some of those offenders in order to make a complete application in that early stage when they first arrive. So the fact that Clause 27A exists demonstrates to us the incomplete information that is coming back with some of these deported individuals, and acts as further evidence why there should be, under Clause 11 of Part 3, under the police taking identifying particulars, an additional set of particulars, and that is the nature of offending. The nature of the offences, and it could be that you could define it, for which the individual was deported from an overseas jurisdiction. Because as it stands, the Policing Act 2008 is incomplete for the purposes of this bill. Now, Mr Speaker, if the Minister refuses to add this, we are creating a rod for our own back. And we will have a farcical situation where a tourist coming into New Zealand for the purposes of visiting casually will be required to give more information on an immigration declaration at the border than we will require a person who is being deported back to New Zealand because of their offending. Because we will not be requiring that same level of disclosure, and we should. It would be farcical to simply rely on being able to access information via Interpol in order to complete information we could simply require to be shared by an offender. For goodness sake, we're taking their DNA samples. That is the highest, the most invasive questioning and gathering of information that is possible under New Zealand law, and yet we won't require them to disclose their offences. So, Mr Speaker, from Labour's perspective, this particular drafting oversight demonstrates to us why, again, and I highlight again, that we would have liked within this part, or indeed perhaps attached to title and commencement, a sunset clause which would have meant that this bill would have expired within a year, and at the same time we would be passing a duplicate bill at first reading that would then progress through the House through all stages to allow us to pick up these kinds of errors, to allow us to give the public to have their say, to allow the legal fraternity to have their say on this piece of legislation, and we would make sure at that point that such errors did not occur. We don't believe that simply having a review after 2 years is sufficient. That means errors like this would remain longer than is necessary, and this Parliament does not operate on the basis of trial, that we put out a law and just see how it goes without having a proper process up front, and that's essentially what we're doing here. So, Mr Speaker, I would really appreciate the Minister giving us a final word on whether she will be undertaking to make that drafting change. Otherwise, we think this is farcical, that it's not included, and again proves our point on the rushed nature of this legislation. I want to speak very briefly in the 1 minute that I have remaining, Mr Chair, to a similar issue around the default provisions in the Parole Act, which this part references, which is the standard release conditions. So again, we have this bizarre reference in this Act that says, in this Act, unless the context otherwise required, a term that is used but not defined, but that is defined in the Parole Act, has the same meaning as in this Act. So basically it's a catch-all that says, if we haven't defined something and you're a bit confused and you don't find it here, you should find it in the Parole Act, we hope. A catch-all phrase because obviously rush drafting. The Parole Act 2002 standard release conditions, on reading, are not designed for someone who is deported from overseas, heavily reliant on existing information being available, heavily reliant on them being released to a known residence, heavily reliant on that person not being transient. These standard release conditions, which we're referencing here, are not necessarily fit for purpose for people who are being deported. Again, it shows the rush nature of this bill.
Chris Hipkins.